All right. Court of Appeal in the 6th District of the State of Florida is now set. The Honorable White Judge presiding. All persons having business before the court is called here to give attention and you will be heard. God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Thank you, Marshall Crawford. Good morning and welcome to this oral argument session of the 6th District Court of Appeal. I'm Judge Keith White, and I do have the honor of serving as the presiding judge here today. Serving with me today, on my right is Judge Petra Brownlee, and on my left, Judge Roger Ganem. Just a reminder, we are being video and audio recorded here today with both of the cases. So please silence your phones and other electronic devices. Also, just for your information, the broadcast is on YouTube. We have a live stream and also would be available for other people who maybe weren't able to attend who would like to watch that at a later time at their convenience. All right, our first case on the docket today is 2024-0130, Gossage v. CSX Transportation et al. Counsel ready to proceed? And counsel, how much time would you like for rebuttal?
I would like to reserve 5 minutes if I may.
That's fine. All right, whenever you're ready.
Good morning, Your Honors, and thank you, and may it please the court. My name is Jeff Mansell. I represent Heather Gossage and the estate of Larry Gossage in this appeal. We ask that the final judgment be reversed because the record establishes issues of material fact that cannot be resolved by summary judgment. These issues include who had possession of the railroad crossing at the relevant time, whether there was an effective delegation of maintenance responsibilities at that crossing, and what the cause of this motorcycle accident was. The trial court drew 2 conclusions in its order on summary judgment, which are relevant to this appeal. The first was that the railroad owed no duty to Mr. Gossage because it effectively delegated the maintenance responsibilities of this crossing to Polk County. The second was that the expert for the plaintiff, Mr. Fisher, and Mr. Fisher's opinions were insufficient to create an issue of fact because they were based on the stacking of inferences. We, of course, contend that both of those conclusions were wrong. Beginning with the duty, there are factual questions in the record of who had possession of this crossing. That is the first issue. Under Florida law, the duty in a premises liability case falls on the party who is in possession of the premises. And the Bovis versus 7-Eleven case, which was, I believe, cited in the railroad's brief, establishes the test or sets forth the test for how we know who possesses property. And it comes down to who occupies it, who controls it. If nobody is presently occupying it, who has the right to occupy it and exercise control over the property. And under that,
Mr. Mansell, I wanted to ask, do I interpret the trial court's order to simply decide that the contracts themselves govern this question? In other words, we can get the answer. I think the court said they speak for themselves. So do we need to know more than what's on the face of the 2 agreements, the 32 and the 02 agreements, to decide this question, or is there factual information outside of those agreements that we need to look at?
there is factual, thank you, Your Honor. There is factual information outside the agreements. And in particular, it is the testimony of Polk County's corporate representative who testified that the agreement from, decades ago, whenever it was in the 1920s or 1930s, did establish an undertaking by the county to maintain the property. There's a separate agreement that I think was entered into in 2001, which Polk County contends actually removes any maintenance obligation from Polk County. And then there's the testimony, I believe it's still from Polk County's corporate representative, that they actually did not have control over the premises because they could not enter the premises at will. They had to have permission from CSX, And in fact, if I remember correctly, from 2001 onward, Polk County did none of the maintenance itself. Instead, CSX performed the maintenance, and Polk County's responsibility was limited to paying for the maintenance of it.
If let's say the contractual arrangement between CSX and the county required the county to maintain some part of that crossing, let's just say, for the sake of argument, up to the actual rails themselves, but CSX voluntarily undertook the maintenance of the whole crossing. In other words, undertook maintenance outside of the rails. Would that determine, as a matter of law, their responsibility or a duty owed to Mr. Gossage in this case, or would the legal language in the contracts control?
I would say, Your Honor, that the actions of Polk County would control, or I'm sorry, the actions of the railroad would control for two reasons. One, because there are two potential sources of duty here. There's the duty imposed on the party in control of the premises, and there's a duty imposed by an undertaking, whether that undertaking is by contract or gratuitous or otherwise. So CSX transportation would still have the duty under the scenario that Your Honor just gave me, under both theories. One, because it is a premises liability case at heart, and the duty in a premises liability case falls on the one with control over the premises. CSX transportation retained the right to exclusive possession and control of this premises at all times. Even under the license agreement, it could kick out the county under the terms of the license agreement, say, can't use this as a crossing anymore. Second, in your scenario, Your Honor, the railroad would have undertaken to maintain the property by actually performing the maintenance, whether it was gratuitous or whether it viewed it as its obligations under its agreements with Polk County. It would be an undertaking. It would be the railroad deciding that it is going to maintain this area of the crossing, both within and outside the rails. And what that would mean was, by undertaking to do so, it had an obligation to exercise reasonable care how it carried out that undertaking. Yes, by the railroad voluntarily performing maintenance, it shows a duty under both the general premises liability theory and under the undertaking theory.
So based on the causation opinion of Mr. Fisher, does the plaintiff contend that it is CSX is fully responsible here, or is it some combination of CSX and Polk County? And how do we decide that?
We believe that it's a combination, and it goes back to, I'm sorry, this left turn is wobbling on. This goes back to my answer to your previous question, Your Honor, about the sources of duty, because we believe that the railroad has the primary obligation as the one in control of the premises, but that because Polk County acknowledges its undertaking with regard to the design and maintenance of this crossing, at least portions of the crossing, that there are parallel duties in this case.
So you mean that the county, even within the rails? I mean, because my understanding was that it was, okay, if it's outside the rails and there's the slope, right? That then would be the county. But what you're saying is, I'm misunderstanding that. And it's both CSX and because of the undertaking, it's the county within the rails.
That's a good clarification, Your Honor. Thank you. No, it does appear that the county's undertaking was limited to the portion of the paving going up to the first rail and then after the last rail, which isn't at issue in this case.
Was it up to the first rail or up to the first end of the tie?
Up to the first end of the tie, which isn't very far from the first rail, but yes, to be precise, Your Honor, you're right, up to the end of the first tie.
And was Mr. Fisher's testimony that, or is it Dr. Fisher? I apologize.
It's Mr. Fisher.
Okay, Mr. Fisher, that there's a problem with this. I mean, I understand about the standards and the argument about the slope, but with regard to the braking or anything that might have gone wrong there, aside from the slope, is it Mr. Fisher's position that the problem was before, such that it would have been the county's duty, or is it after, and then because of the slope within the rails?
So Mr. Fisher, he doesn't really give an opinion on whose duty it was. I mean, he looked at who owned it.
But we're to gather that just from the location is my understanding.
Yes, Your Honor, and the property records and the contracts and the testimony. And it might be good to just summarize and paraphrase what Mr. Fisher's opinion is.
Okay.
Because it has to do with both the portions that lead up to the railroad contends with Polk County's responsibility and the portions that are unequivocally the railroad's responsibility. So Mr. Fisher's opinion is that there are a couple factors that had to coincide for this accident to happen, for this crash to happen. Approaching the crossing, there's an uphill grade and everybody brakes. I mean, any motorist would brake going up that uphill grade toward a railroad crossing. Sensible people do not accelerate or maintain their speeds going over railroad tracks. So everybody agrees, Mr. Gossage and everybody else were applying brakes. And as they're going uphill, of course, the application of the brakes causes the weight on the motorcycle to shift forward around the center of gravity. So under normal circumstances, you apply the brakes, weight shifting forward. Now, what Mr. Fisher refers to as the geometry of this crossing creates a ramp going up to that first rail. So as you crest at that first rail, on any vehicle, it'll remove some of the weight that's being shifted to the front, and that's what refers to as a decompression. The grade then shifts downward between the first two rails, and when the front wheel then makes, the weight comes back down, there's a drastic compression at that point that wouldn't happen just from braking. It has to involve the geometry of it. So then by suddenly compressing the weight on the front wheel, it causes it to bounce, and there's a compression, decompression going on, which causes the skip skid, as the experts keep calling it, at this crossing. So then the grade once again shifts upward, going from the second rail to the third rail, the second set of tracks. And then because it's going uphill, as it's kind of skipping, compressing and decompressing, the weight goes all the way back on the front wheel. There's full compression on the front wheel. It completely locks up, and that's when he washes out.
So the problem begins with the slope.
Yes,
So
Your
it's
Honor.
outside and then continues and under your theory and crosses through the tracks.
Yes, Your Honor. There's an interaction of all these changes in grade, what Mr. Fisher calls the geometry.
So then we don't really need to resolve. Is it true under your theory that we don't need to really resolve duty with regard to inside the rails and duty with regard to slope and outside the rails in order to determine whether there's a disputed issue of fact? Like, and that might not be stated very clearly, but if we agreed with you, hypothetically, then they would both have duties, right? There's this coexisting duty because the beginning of the problem and the end of the problem.
Yes, Your Honor. Yeah, and that was going to be part of my spiel on the duty, that, there are disputes about just how far CSX Transportation's control extends, but there is also a dispute over, all of the interactions of all these portions of the crossing that were unequivocally under the railroad's control and unequivocally part of Polk County's maintenance obligation.
Counsel, my understanding is that your client's contention as part of the duty of both the county and CSX is the duty to maintain. Is that correct?
Yes, Your Honor.
But when I read Mr. Fisher's relevant portions of the deposition cited by you and your opposing counsel, as I read his testimony, when I heard geometry, that to me seemed to be a design issue, not a maintenance issue.
Well, so yes, Your Honor, I suppose there are both design and maintenance elements of this. But in maintaining the crossing, both the railroad and the county can mitigate these geometric effects.
Where is the basis of that in the record? What you just said, that argument you just made.
I think,
for example, and maybe this will help because I don't want you to get a puzzled look, so maybe my question is not clear. So if you have, say, the road up here 30 feet out, use that, your expert used that from the center line of the rail. So you say you're 30 feet out, and say the elevation from some basis point is 100 feet. And the rail's down here at 5 feet. You would agree with me that from a geometric standpoint, there's going to have to be a decline, correct?
yes, but you can mitigate the effects of that by adjusting the grading through fill and through pavement.
Which is design, design and or construction.
Yes, but you can do that by changing it after it's initially designed. So, and maybe I'm misunderstanding your question, but this doesn't all come down to the 1922 design of the crossing. You know, when there's maintenance in 2001, I believe, and that's partially in response to an FDOT inspection, if I remember correctly, that identified problems with geometry. You know, part of the point of going back into the site and, you know, repaving or performing maintenance is to address
That 2002 agreement that you referenced.
This
Is that
may
what
have
you're
been
referencing,
for
the 2002 agreement?
I was referencing Mr. Fisher's testimony about his review of an FDOT inspection and some subsequent repairs and maintenance at the crossing. Which,
I mean, the 2002 agreement refers to construction, reconstruction, or otherwise changing a portion of the public road.
okay, yes, Your Honor.
And that indicates that that's an FDOT project.
I think you're right.
So it means they were doing the design and construction. Is that correct?
I was under the impression that CSX Transportation actually did the work.
Did the work or maybe had some obligation? There is some cost shifting in here in this agreement that I saw.
My recollection of the record is that CSX Transportation did the work and Polk County reimbursed it for the costs.
Okay, so I guess what standard is it? Because I certainly, I think you gave a very good summary in terms of your expert's testimony about how the loading on the suspension, et cetera, changed because of this decline and incline, then another accepting your expert's testimony and the light most favorable. Okay, there's this undulation, I'll call it. But where is this? And I did see the standard about it being on the same plane and the difference in elevation of plus or minus 3 inches, 33 feet out. But where is the standard in terms of the design of the road? If you're saying that this road was constructed at, well, I guess first, where in the record is that CSX and or Polk County constructed or designed the road or assumed the obligation to do so? I didn't see it, but maybe I'm.
Yeah, and Your Honor, I apologize, but this, you know, this wasn't really the argument at summary judgment. So I didn't familiarize myself with the part of the record that you were asking about. You know, summary judgment was really turning on, you know, can the expert say this? Does the court have to accept it? And who's in control of the premises? And neither defendant raised the issue of, well, it wasn't even us who was responsible for this in the first place. You know, nobody put it on FDOT to establish these grades. So,
Well, I mean, my understanding is the issue was maintenance, but I thought both defendants did argue that there was no insufficient evidence to show that there was negligent maintenance. Maybe
I consider their argument to be that there was insufficient evidence that it was in a dangerous condition, which is different from saying we weren't the ones who did this at all. It was FDOT. And the evidence, I mean, the evidence from Mr. Fisher was that it was in a dangerous condition. So, Your Honor, in my time listening to opposing counsel, I can glance at the record. I'm not sure I'll be able to answer your question today about how it is that these grades came about, because it seemed to be accepted that it was either Polk County or it was the railroad that was responsible for what we call the geometry at the crossing. And that, as far as I could tell from the motion and the response, that point was undisputed. And in my rebuttal time, fairly severely, Your Honor. So
no, that's I asked you for a question, and I'll give you some time to account for that. Any other questions?
no. Thank you, Your Honor.
All right, thank you, counsel. And have Appellees determined how they're going to allocate their time?
Yeah, Your Honor. Dan Fleming on behalf of CSX Transportation. I've spoken to counsel from Polk County, and we've allocated the time 15 minutes to me, 5 minutes to Polk County.
One second. said 15 for you, correct?
Yes, sir.
All right. All right, are you ready?
I am ready.
Go ahead.
May it please the court, Dan Fleming of Johnson Pope, on behalf of CSX Transportation, Inc. The judgment of the circuit court should be affirmed. Judge Raful's detailed 12-page, it's actually a single-spaced order, so it's really like a 25-page order granting CSX Transportation's motion for summary judgment and setting forth the reasoning he utilized in arriving at his decision in direct compliance with Florida's new summary judgment law as of 2021. Should be affirmed for three reasons. The first, and the real all three separate reasons, I think. The last two kind of dovetail together, but the first one, every single allegation of negligence relating to sections of the highway grade crossing for which CSX Transportation is demonstrably not responsible. Every single allegation is outside of what CSX is responsible for. And contrary to what you heard in some of the briefs and what you heard in some of this argument this morning, the record evidence is completely devoid of any evidence that CSX had any responsibility outside the ends of the ties, as Judge White pointed out. It's not the end of the rails, it's the end of the ties, which extend about 18 inches beyond the rails. So you basically have, if you're familiar with, everybody's kind of familiar with tracks go like this, the rails are perpendicular to the rails themselves. They extend about 18 inches beyond the ends of the rails. That is the sole area of maintenance responsibility that CSX has at this particular crossing.
Counsel, if I can interrupt
Sure.
on one point, the railroad ties, and you look at the different schematics, you can see them, and they, by definition, they tie the rails together. So they go perpendicular. The rails go like this,
Correct.
The ties go like this. But then there are these pieces, and the evidence is replete with reference to these pieces of wood, the wood timbers that parallel the rails. Now, are they coextensive in terms of the edge with the edge of the tie? Because that wasn't clear to me from the record.
They are. If you look at the photographs, if you look carefully at the photographs, you'll see they all come together. I mean, the area of maintenance is, and this is the most important, critical point of this case relative to this first point. There is no dispute in the record, none, not one single piece of evidence in this case in the record indicates that CSX had any responsibility outside the ends of the ties. And that is,
So let me ask you
Sure.
on that point,
yes, sir.
because we're dealing with, I think in the premises liability question, we're dealing with control, not necessarily responsibility. And so if when you make your point, you would address in the 2002 agreement on the third page, or I guess it's the second page, it's paragraph 3. It says that the CSX will maintain at its expense the track and rail components and highway surfaces for the area of the crossing between the ends of the railroad ties. And the county shall be responsible for the maintenance and cost of the highway roadbed outside of the railway ties. So far, that's what we're talking about. But then the next sentence says, it being expressly understood and agreed that CSX may, at its option and upon notification to the county, perform such periodic maintenance work and bill the county directly for costs thus incurred that are the responsibility of the county. And I read that to mean CSX might only be responsible for what's between the ties, but at its option, it can do more and just send the county a bill. Why is that not control beyond the edges of the railroad ties?
Well, because it's plainly not, and there is zero evidence in the record, not one shred of testimony, not one document. That interpretation is, with all due respect, Your Honor, wrong. The particular.
Well, it's what it says.
Well, let's go to what it actually says, because if you look at the actual two agreements, paragraph 2 of the 1932 agreement specifically requires Polk County to construct and maintain the highways upon CSX Transportation's right-of-way. Nothing in the 2002 agreement negates that obligation. I'll go directly to the portion you read from. Paragraph 7 of the 2002 agreement expressly provides that any provision contained in any existing contract relating to said crossing shall remain in full force and effect except as otherwise provided herein. Thus, absent clear and explicit language to the contrary, which does not exist, the county's duty to maintain remains intact. And if that language of the both contracts are very consistent with regard to this, it's a very common, normally the contracts are with FDOT, with the municipality, in this case, Polk County. These are very common contracts. It's what we look at every single time. I've been doing this for decades. When there's an accident, the first thing we go look at the agreement. This agreement is standard. It's very easy to interpret. The idea that we can build them, again, remember, the tracks are there first. We own the property. We have a railroad crossing there. They're putting a road over it in 1932. The language that you're referring to allows the railroad for any work that it has to do because of, again, work within the ends of the ties that they have to do. They bill the county because that road we wouldn't have to do that work. Ostensibly, the maintenance that we have to perform at a crossing is much more extensive than down the tracks when there's not a road with cars going over it all the time. In that particular area, when we do work, we bill the county and they pay us. Otherwise, we close the crossing. That's what the evidence shows. There, again, and this is critical. There is no evidence in this case, despite what you see in some of the briefs and what you've heard today from the podium from opposing counsel. There's no evidence in this record that CSX ever did any maintenance outside the ends of the rails, consistent with the language in both agreements. And if that wasn't clear enough, two people in this case have testified. The two corporate representatives from Polk County and CSX, both of them testified completely consistent with what I just told the panel.
But that's not what the trial court found, right? The trial court finds a wholly separate issue with regard to duty. I see you're puzzled by it, so
I am puzzled, yes.
with regard to the subservient estate and the dominant estate, and when there is a non-delegable duty, it just seems to me that I think that what you're saying is consistent, right? Like I'm following you with regard to the agreements and the testimony. But what I'm concerned about is the trial court's finding with regard to duty and why he is saying that your clients don't, or that the county and CSX has no duty in the case.
I don't think he said there was no duty. I think he very specifically acknowledged what the agreements say is that CSX's duty was confined to the area between the rails. And that's where I'm going with this whole point. I think it'll bring it home for you, is irrespective of what the county now says or what counsel says here in argument, there's no evidence in the record that our responsibilities go beyond the ends of the ties. And then to tie it together, there's the record evidence in this case is equally clear that there is no allegation of negligence within that area. As you're
Within what area?
within the ends of the ties. All the evidence of negligence is 30 feet back and 2 feet back. And that comes directly from plaintiff's expert, Mr. Fisher, who testified conclusively. And he was specifically asked, what about the area between the ties? I didn't look at that area. My testimony is about 30 feet back and 2 feet. Again, both of them outside. Again, remember, the ties extend about 18 inches beyond the rails. 2 feet is outside of CSX's responsibility. If you believe those allegations are correct and had anything to do with the accident, which is again, obviously contradicted by the common sense notion that you had 6 riders, you've had no prior complaints, you've had no prior accidents, you had 6 riders riding normal motorcycles on that particular day, not a chopper motorcycle with only 3 months of experience. They traversed the crossing without incident. And again, that's what the evidence shows in the case, not what people are now talking about. Well, my impression is CSX was doing this, there's no evidence in the record. CSX's responsibility was confined between the ends of the rails, and the allegations of negligence are outside of that area.
What about Mr. Fisher's testimony, and correct me if I'm wrong, that there was a downward slope past the first rail and then an upward slope again before the third rail or the next set of tracks? Isn't his testimony that there was a problem with the grading in between the rails?
Yeah, in between the rail again. So again, you got 4 rails here, so it's a little confusing, understandably. But no, first of all, it's not Dr. Fisher or Mr. Fisher's testimony in that regard. That's what is argued in the brief, and they talk about it. If you look at it, it's confined to, because they didn't refer to Mr. Fisher's testimony regarding that point because they couldn't, because he didn't testify about that. Again, look carefully at the record. When I asked Dr. Fisher, what about the areas specifically between the ends of the ties? I didn't find an opinion specifically about that area. The area you're talking about is between the 2 sets of tracks. So between the second and the third rail, and that's where they talk. Again, you've got 2 sets of tracks here, which is where the county back in 1932 decided to build a road. You got 1 track here, 1 track they're not exactly, on an even keel. So it necessarily is going to have to be a grade between there. That's not a violation of anything. Again, I don't want to go, it's a red herring to go down the whole statute, because what the court found, and going back to your question, Judge Brownlee, what the judge found was not that there was no duty here. It's that the duty of maintenance cannot be connected to any allegation of negligence or causation in this case. Again, all he's saying, and here's where you really get down to the second point. The first point is all the allegations of negligence are outside CSX's responsibility. That's in and of itself, end of story, affirms. But even if you get beyond that point, then you go to the actual opinions Mr. Fisher formed, and they were clearly based on an inference. You don't have to wonder about it. All you have to do is look at Mr. Fisher's testimony. He acknowledged that there was no testimony from anybody about how Mr. Gossage braked his motorcycle. Zero, no testimony. He had to infer, and did infer, based on Mr. Mortara's testimony. He was the one guy behind him. Again, they're driving staggered over this railroad crossing. Everybody traverses it safely except for Mr. Gossage, who's driving a different type of motorcycle. He's only been on it for 3 months. He brakes 30 feet before he even gets to the crossing, starts to skid, loses control, falls down somewhere around the crossing. Again, the evidence in this case is that Mr. Gossage fell near a railroad crossing. There is no evidence in this case that he fell because of that railroad crossing. And that's what Judge Raffoul determined. And if you look at his opinion, he did exactly what the Florida Supreme Court. I go back to, math when you were a kid and you're doing your math. Remember when you had to do your math and you couldn't just write the answer down? You had to show your work. Well, Judge Raffoul shows his work. If you look at paragraphs 23 and 25, all this nonsense about, Judge Raffoul was acting as a battle of the experts, or he's trying to substitute, become a fact finder. That's not what he did. Look at the language he used. In paragraph 23, he begins it with, the experts agree. He didn't base his opinion on anything they disagreed about. He may have put that in the order, but what he actually ruled upon, and you can see it in his ruling, he said what they agreed upon. What Judge Raffoul did was he did look at the evidence in the light most favorable to plaintiff by only relying on evidence that the experts agreed on. They agreed they break 28 feet back. So the only thing was, Judge Raffoul said, well, how do you get around the fact that this guy braked differently than everybody else? And that just caused the accident. No answer for that, zero. And that's why you get to the food fair case, but I don't want to get too far ahead of myself. When you look at Tim Mortara's testimony, I mean, please.
Counsel, if I could stop you on that, but
sure.
But why is that the plaintiff's burden to show that he braked properly?
Well, because specifically under Florida law, if you can't, because if he braked improperly, that and
Sounds like comparative negligence.
No, sir.
No?
It goes directly to, if you look at Mr. Fisher's testimony, he was specifically asked, could Mr. Gossage's braking be the cause of this accident? He said, yeah, it could. But Mr. Fisher disregarded that and came up with this theory of the relatively flat crossing, having all these up and down motions. The fact that he acknowledged it could have been the sole cause and couldn't exclude that, that's where you get to Florida law. This is a Supreme Court case. Food Fair very specifically says that if you've got a reasonable inference that could have caused the accident, which Mr. Fisher specifically agreed could be the case, you have to be able to reasonably exclude it. He couldn't do it. He didn't do it.
Do you acknowledge, counsel, that the rule is somewhat different with regard to expert witnesses for stacking inferences?
Different in, yes, if they're only, yes, obviously it is, if the expert relied on direct evidence for his opinion. And that's what you don't have to wonder about, because I specifically asked Mr. Fisher. Mr. Fisher was asked. He clearly is infirm. I mean, if you look at Mr. Mortara's testimony.
He's allowed to infer, right? I mean, he's an expert witness.
Well,
So he can't speculate wholly, right, under the case law.
He can't speculate wholly, and he can't completely infer. He has to have, unless that inference is raised to some level of fact, and that's clearly not the case here. If you look at Mr. Mortara's testimony, look at the language he used.
So do you not think testimony is evidence?
It could very clearly be evidence. Let me make sure you understand what I'm saying. If Mr. Mortara had said, I saw Mr. Gossage's braking, and I believe it was reasonable because I saw it and I knew, he didn't say that. Mr. Mortara doesn't give any evidence regarding. He said, again, look at the testimony of Mr. Fisher. He's not relying on Mr. Mortara's testimony. If he did that, you're correct. Then it would be, he's relying on direct testimony. You can rely on testimony. You can infer from testimony. but you can't make an inference about testimony and come up with your opinion if it doesn't exclude other reasonable inferences, which his clearly doesn't. Look at what Mr. Murtara's testimony is about speed. He doesn't testify. First of all, it's important, critical. He didn't testify about how Mr. Gossage braked. Again, he's not relying on Mr. Murtara's testimony about how Mr. Gossage braked for him to come up with the opinion that Mr. Gossage braked appropriately. He's relying on Mr. Murtara's testimony about how he came up upon him about speed. And he said, I don't know, I was coming up about the same speed, kind of close. I'm not really sure. Didn't really look at that. He doesn't have any testimony about how Mr. Gossage braked. He had to and necessarily did infer from Mr. Murtara's testimony that based on the fact that Mr. Murtara couldn't remember how much he was coming up on him, then Mr. Gossage must have braked appropriately. That's an inference. You can't start with an inference and stack them. That's specific what is impermissible stacking of inferences. You have to start with
Counsel,
the
I'm sorry.
fact. Yeah.
Has he answered your question or?
That's
you-
fine. Yeah, go
Okay.
ahead.
Any
I had
other
one
questions?
more, and maybe we can give some more time to
We will.
to the county. As an expert witness, would it not be appropriate for Mr. Fisher to give an opinion that assuming normal braking, it was the condition of the crossing that caused this accident? And then let the question of whether he braked normally or improperly be submitted to the jury. Why is that not appropriate for an expert witness to give an answer to even a hypothetical question that assumes appropriate braking and gives an opinion about how the crossing caused the accident?
Well, I'll start with saying that's not what happened. But your question, could that potentially be something that could go to a jury? Maybe, but it didn't happen here. And specifically what did happen here is he inferred, and specifically, if you look at what Judge Raful did in paragraphs 23, 24, and 25 of his order, he specifically looked and said, look, you can't exclude the fact that what they're saying actually occurred. He didn't pick one expert over the other. He just asked, can you exclude this reasonable inference?
But isn't the question here whether a jury could conclude based on Mr. Fisher's opinion that the crossing or the condition of the crossing caused the accident? It's not up to the plaintiff to exclude every other possibility. It's simply the plaintiff's obligation to put forward some evidence and then let the finder of fact decide.
Not the case anymore. I respectfully would disagree. It is very, if you read the food fair case, it is very specifically the plaintiff's responsibility to exclude any reasonable inference that has been presented.
You're talking about the stacking of inferences question, right?
Well, it's both. And that was gonna be my third thing is the food fair case. The stacking of inferences is impermissible. That can't be the cause that you submit to the jury, where you're asking them to just pick the one that we speculate about and not one that you have to be able to exclude any other reasonable inference. And clearly, in this factual scenario that presented here to Judge Raful, there was a reasonable inference that Mr. Gossage braked too hard. In fact, their expert agreed it was potentially the cause of the accident. He just came up with a theory different than that. But to do that and to submit it to the jury, getting directly to your question, you would have to exclude other reasonable inferences, and they couldn't and did not do that here. That's the third reason that affirmance is absolutely mandated. But all of your questions go to.
Counsel, I'm sorry. Has he responded to your question?
Yeah,
Anything else? All right. All right. Thank you, counsel.
thank you for your time. I would rely on our brief for any questions we didn't get asked or anything that were raised on in rebuttal. Thank you.
Thank you.
Score.
1 second, counsel. Afraid this is above my pay grade.
I'm not gonna talk for very long, but
I'm trying to get your 5 minutes set up here.
Yeah, you're going down. Go down.
All right, let's go with it.
okay. Thank you, Your Honor. I'm John Trone from Lakeland on behalf of Polk County. I ask that the judgment be affirmed based on the speculative nature of the proof that was offered. I'm here to speak a little bit further, though, on the part about scope of maintenance, only because I don't want to be railroaded, as I think.
Did you practice that, counsel?
It occurred to me on the drive from Lakeland. I said I got to work that in. But as your Judge Gannon mentioned, I think the duty regarding maintenance is contractual as it relates to Polk County. We're a licensee, not an owner, so our duties are contractual, and those say very specifically that we're only responsible for maintenance costs. The railroad goes out there, they maintain the entire crossing. If there's asphalt in the middle, they'll send us a bill for that, but we don't touch it. And respectfully, I disagree with counsel for the railroad about not having a shred of evidence, and I'll point the court to page 1340 of the record. And this was the testimony from Polk County's representative about that issue. And he said, it's just a very short 2 sentences. So if there's an issue there with their rail components, they would maintain that at their expense. But anything outside of the railroad ties, they would maintain at the county's expense. So that's what the county would reimburse him for. So with all respect, there is evidence in testimony, but
Counsel, sorry to interrupt you.
Yes, ma'am.
Is it your understanding that the trial judge ruled that your client does not have a duty in this case, or was the trial judge truly making a causation determination based on what the experts testified to? And I understand your argument to be either that the expert that Dr. or Mr. Fisher was testifying based purely on speculation, or that it was the improper stacking of inferences. But is it true that in your mind that he really just ruled on causation?
I would like to think so, but there is a little dicta in there where he talks
With the
about
duty.
the scope of maintenance. And that's what upset me, because when this motion was filed, it wasn't directed at all to the county, it was directed exclusively to the plaintiff. And it says in here, and I'm reading from CSX's motion, at best plaintiff may establish Mr. Gossage fell in the vicinity of the railroad crossing. However, she is unable to establish Mr. Gossage fell because of the railroad crossing. So I took it that this is a motion directed exclusively to the plaintiff based on that theory that they can't prove how this person actually fell through overbreaking or through some other error, but not necessarily because of the condition of the road. So I merely joined in that portion of it, not thinking that the judge would issue an order basically declaring, well, he didn't really declare, but he did read the contract and said the contract speaks for itself. But then he goes and mentions that it's undisputed about where the scope of duties was, and that's not the case at all.
But certainly you're happy with the judge, with the outcome, right?
Yeah. I mean, I would like it affirmed, but only because it's based on speculation as to what effect, if any, the roadway had on this, because they can't establish where he began breaking and what effect the undulation or the slope may have had to it. And to I think it was Judge White that brought up the slope point. This was a reconstruction in 2002, and DOT was involved, and all of their specifications were attached to it. So on behalf of the county, you know, regardless of who constructed it, they constructed it according to FDOT specs. And I think that was one of the criticisms that the
Counsel, who owns the road? Does FDOT own the road? Does the state take the road, or does your client own the road?
The road leading up to the crossing,
Correct,
is owned by the county.
Okay.
But there was a mention that, and I think counsel for the appellant said that we maintain, or we built up to the tie. I don't think that's correct. I think every time this crossing has been redone by CSX, and it's been done a few times over the years, they do the work. They send us a bill for whatever asphalt was spent in between the ties. That's it for the county. But I wanted to mention the slope part because, and this gets back to your argument, is this a causation argument or not? The slope was built according to FDOT specs in as far as that 2002 agreement goes. There's no evidence from their expert that there's any problem with this, with the slope. Maintenance, as you described, is this a maintenance or a design issue? Well, I mean, it was designed according to FDOT specs, and there's no evidence from their expert that there was, you know, somehow some maintenance issue. So I think we have a better argument than actually CSX for getting out of the case based on speculation, just because there isn't any evidence of some failure and negligence on the slope leading up to the crossing.
Counsel, you know, 5 minutes goes pretty fast.
Boy, that was quick.
Note,
Yeah.
if any of my colleagues have any other questions.
Okay, thank you.
All right, thank you. All right, counsel, I'm going to give you a total of 10 minutes for the extra argument that your opposing counsel got in total, as best of my recollection. You don't have to use it all, but I'll give that to you should you desire. All right.
Thank you, Your Honor, for both giving it to me and telling me I don't have to use it all. I really just want to highlight a few points, and I want to start with the expert testimony because I spent way more time on duty first time I was at the lectern. We have to consider where this whole idea of overbreaking came from. And it came from the railroad's shifting theories on what caused this crash. They filed a motion for summary judgment saying plaintiff can't prove it had anything to do with us because it was most likely the failure to maintain the motorcycle appropriately. And we think the plaintiff or the plaintiff's decedent had a bicep tear, which caused him to lose control of the handlebars. Mr. Fisher signs an affidavit, gives his opinions, and then there's a new motion for summary judgment with the defense expert opinion that no, it was actually overbreaking that caused. So Mr. Fisher didn't address overbreaking because nobody had ever said overbreaking before. It was entirely a defense theory. So there are a couple reasons why the trial court should not have held plaintiff to the burden of completely disproving this overbreaking theory. One, it's just not a presumption that a plaintiff has to overcome. There's no underlying presumption that the accident was Mr. Gossage's fault, which is really what overbreaking posits, right? Overbreaking means you applied the brakes improperly.
I think what opposing counsel was stating, if I'm correct, is that there's an impermissible stacking of inferences and a speculation done by Mr. Fisher, and that it cannot be purely speculation. I think the stacking of inferences is nuanced with regard to expert opinions, but he's saying, oh, it's purely based on speculation. So can you show us why it's not purely based on speculation and how this expert witness can get over their theory that it's an improper stacking of inferences?
A couple things, Your Honor. One, the idea that Mr. Gossage braked as normal is supported by the circumstantial evidence. And I know Mr. Mortara did not say Mr. Gossage braked as normal, but the description of everybody involved here was that they were experienced motorcycle riders. They were all approaching this crossing at about the same speed. And the fact that Mr. Gossage had ridden motorcycles for a very long time, had not washed out at railroad crossings or at any other point. And Mr. Fisher's analysis of the skid marks and the role that the so-called geometry and the ramp played in this all lead to the conclusion that overbreaking was not the sole cause of this accident. And I want to emphasize that last point because that's really all that the plaintiff is required to do. We don't have to rule out completely that Mr. Gossage's negligence contributed in some way to this crash. What we have to do is show through some admissible evidence that one of the causes, one of the legal causes, was the failure to design and maintain this crossing. And that can happen even if Mr. Gossage did overbreak. So Mr. Fisher's opinion is that he did not overbreak, but even if that were rejected, that wouldn't affect the salient opinion he has that one of the contributing causes to this crash was the condition of the crossing. And that was the main point I wanted to make there. In addition to the fact that, as noted already, the stacking inferences analysis does not apply to expert opinions, and the Zach versus Centro case could not illustrate this better. Almost the precise same thing happened, except I believe it was a JNOV in Zach and not summary judgment. But the court said, the trial court said in Zach, this expert testimony was insufficient to create an issue of fact because the expert disregarded all of the witnesses and documents saying that there was no negligence and it didn't cause his injuries, and instead drew these inferences from circumstantial evidence that the defense did cause these injuries. And I think in that case, it was the allegation was a nurse removed a catheter while the cup was still full. All the witnesses said the cup was empty. The documents said the cup was empty. The expert said, I think it had to be full based on the circumstances of how this all happened. And the trial judge said, that's not good enough. And the second district reversed on that. That was followed in the Dumigan case from the, I want to say 5th district just a couple of years ago. The other case that I think really informs the outcome of this is the Bond versus Columbia County case. Now that's a little bit different because the trial judge even made a Daubert ruling in that case, which the judge here did not. But the appellate court in that case said that in making inferences, the expert is entitled to rely on any view of the evidence. He can reject portions of the record. He can accept other portions of the record and draw inferences from those portions that he accepts. That is not a Daubert problem. It is not a summary judgment problem. And that's what Mr. Fisher did here. He did a site inspection. He reviewed witness statements, and he is an accident reconstructionist who applied normal standards of accident reconstruction. So I just disagree with opposing counsel's characterization of how this should even be analyzed, because echoing the trial court, what the railroad is saying is you have to look at this first inference of overbreaking and overcome that conclusively. And because that's not a presumption and that's not an initial inference that's material to the opinion anyway, that's just not the analysis that the trial court should have employed. And for that reason, it should be reversed. Now, Judge White, I promised you that I would look at a couple things when I got back to my table. I reviewed the motion for summary judgment that Polk County, or I'm sorry, that CSX Transportation filed. I did not see anything raising the issue that the grading of this was FDOT's fault and had nothing to do with the maintenance or anything that the railroad of Polk County did. Because it was not, in my view, raised in the motion for summary judgment, I don't think that in the trial court we made a record on how this came about.
So to make sure I'm understanding, so you agree, and based on CSX counsel spending a lot of time talking about it, that their argument was, we don't have a duty because we're not responsible for that area at all.
Right. That was the argument, and that's what we focused on. I will say that, Polk County's answer brief on page 18 talks about the 2002 actions and what CSX Transportation did and what Polk County's financial responsibility was. On pages 2835 to 2836 of the record, Mr. Fisher discusses how FDOT identified problems with the grading, and I think he said they suggested a grade out, which I think we could have developed further if this issue had properly been raised. To note that by FDOT suggesting a grade out, CSX Transportation had the opportunity, or Polk County, if they continue to contend it was Polk County's responsibility, they had the opportunity to do that grade out in response to FDOT's suggestion.
And I'm sorry, what portion were you citing in Mr. Fisher's testimony?
It's on pages 2835 to 2836 of the record on appeal. And Your Honor, I want to stress that that's just what I was able to come up with at this moment. I think if it had been raised in summary judgment, we would have had more to say on the subject. But the trial court definitely did make a ruling that the railroad did not owe a duty. And what it did not do is make any ruling that Polk County did or did not owe a duty.
Do you think that the trial judge's analysis with regard to duty was correct? And whether it matters ultimately for their purposes might be up in the air, but with regard to sort of this easement and the dominant estate?
The trial judge did that because I noted it in our response to summary judgment. And, in hindsight, I regret that because I don't think it's really material.
Thank you.
But, the idea of the serving and dominant estate, that only comes up when one party owns the property in fee and another party has an easement over it. And then there's pertinent easements and easements in gross. But here, the only property records that anybody knew of were CSX Transportation owns this whole area, the whole relevant area where this occurred. And any duty on Polk County would arise solely under the contract.
Where is, when you say the whole area, what document are you referring to that talks about who owns this whole area, whatever you're referring to there?
There's the initial license agreement that talks about, that describes the crossing as a whole, as the property of CSX Transportation.
You're talking about the 1932 agreement?
Yes, Your Honor.
Well, yeah, it refers to this blueprint, but I couldn't find that blueprint anywhere in the record.
Yes, and then Mr. Fisher's testimony, based on his review of the property records, he gives the number of feet extending out at the property records.
I'm sorry, who's that?
Mr. Fisher.
Mr. Fisher?
Yeah.
Okay, and where is that in the record?
Oh, good Lord, Your Honor. I do not know. I know
So he examined property records?
he
Mr. Fisher
looked
did?
at the appraiser's records.
Oh,
So
okay.
if I were,
The
if
Polk
I-
County property appraisers? record?
yes, if I were to look at this for Your Honor, I would do a word search for appraiser. That's how I would find the answer in Mr. Fisher's deposition.
All right, thank you.
And I used more time than I anticipated, but I wanted to thank Your Honors for the opportunity to argue this case.
Any other question? All right, thank you, counsel. All right, thanks to all counsel for preparation and helpful argument for us. Thank you very much. All right, counsel, in the next case, can come forward and we'll give you a moment to get set up. Counsel for the next case, ready?
Ready, Your Honor. And I'd like to reserve 5 minutes. I see that you have that.
All right,
set that way.
our next case on the docket is 2024-858 ASS Monkey LLC v. Orlando Apopka Airport Association, Inc. All right, counsel, you have 5 minutes for rebuttal. All right.
May it please the court, Alan Lawson on behalf of ASM. I want to start with the first question that seems to have been presented as to what the law is in this area. To us, and we briefed it and listed a lot of cases, the law is that for a condominium association and its board of directors to restrict the use of or exercise control over the use of an individual unit owner's property, that power has to be expressly granted in the declaration of condominium or in some other restricted covenant that's recorded in the public record and runs with the land. We've cited a number of cases on that in the answer brief, and I'll just give one of the many examples at pages 26 and 27. The association cites Beechwood Villas Condo versus Poor for the proposition that the association is empowered to establish rules and regulations, including those in its guidelines, so long as those rules and regulations do not contravene an express term of the declaration. In other words, they suggest in their argument that they have some inherent police power and can control unit owners' property, irrespective of whether there is an express grant in the declaration, so long as their rules don't contradict the declaration. What that case actually says is that the use restrictions And use restrictions is a term of art and would include things like aesthetic guidelines. You can't paint it this color, you have to paint it that color. The architectural guidelines that are at issue. Use restrictions that are contained in the declaration are presumed valid. Board rules, quote, are treated differently. When a court is called upon to assess the validity of a rule enacted by the board, they must first look to determine whether the board acted within its scope of authority, and that's as set forth in the recorded declaration that is provided to the owners at the time of purchase so that they have notice of what those rules are. There also seems to be some question presented in the briefing as to the second legal principle I want to talk about, and that is that restrictive
Counsel, if I
covenants.
can interrupt
Yeah,
on that last point. So the declaration was recorded in the public record.
correct.
What about the bylaws or the rules or some of these other ancillary documents, I'll call them? Were they recorded in the public records? Were they provided to buyers at the time that they purchased their property? That was not clear to me in the record. Maybe I overlooked.
Okay, so you mentioned bylaws, and the bylaws for this association were adopted with the declaration, recorded with the declaration. And so those are in the public record, and the association and all the unit owners must comply with the bylaws. The guidelines that we're talking about are not part of the public record. There's a dispute of fact as to whether they were adopted by the board. There's testimony that there was by the board member, the president, and the chair of the Architectural Control Committee. But in discovery, when they were asked to provide those minutes, they couldn't provide any minutes where they were adopted. And there was clear from the testimony, there was no notice of these meetings. So anyway, and when they were asked in discovery when they were adopted, it simply said in board meetings. But that's irrelevant because the real question is, did they have the authority to adopt them? Because they were not part of the declaration. They are not reported in the public record. They're simply something that was on their website, along with instructions about what you need to do to comply with them. You need to submit the information, which of course my client did, starting in October of 2016.
Counsel,
Yeah.
oh, on that point, where the declaration simply has language like our declaration here, that a unit owner can't do something to its property without the written approval of the board. If that's the only language giving the board that power, what limit is there on the board's discretion to give or not give written approval in a situation like that?
There would be. There would have to be more. In other words, there would have to be something that authorizes use restrictions to be adopted by the association. And in here, there's contrary language. And I'll just run through this. First of all, a unit's defined as property subject to exclusive ownership. An owner is defined as the person who owns fee simple title to a unit.
And I'm sorry, counsel, everything you're reading is from the declaration?
This is from the declaration. A unit owner, according to the declaration, may make such improvements to his unit at his sole personal cost as he may be advised. And then if you look over to the section on use restrictions, that's section 11, but Article 11, section 1 of the recorded declaration, in all caps, the first section says each of the units shall be occupied and used by the owner or owners thereof for such purposes as are permitted by the applicable zoning regulations and are not prohibited by the association as hereinafter described in the declaration. And so there's a whole section on use regulations, and it says that the structure has to be permitted and permittable. It cannot impede on the common elements. It cannot be used for an improper, immoral, offensive, or illegal purpose. It can't constitute a nuisance. Interestingly, it can't have an antenna on it, and it can't increase the insurance cost of the association. Those are the use restrictions. And if you look at the bylaws, and I'll go there, the bylaws say that the board has the power to adopt and publish rules and regulations governing the use of the common areas. That's it. They don't have the opportunity or the grant of authority to adopt rules and regulations governing use of units. That is handled in the declaration. And what it says at the end of, let me find that. Yeah, so end of Article 11. So Article 11 is use restrictions. And it says the owner can do anything they want except for these restrictions. It lists them out. And then the last section, Section A, says that reasonable rules and regulations concerning use of the condominium property may only be adopted or amended by a vote of 75%, a supermajority vote of the unit owners. And interestingly, here we have the drafter of that document, Mr. Thompson, who was the original developer. And he said, that's exactly the way I wrote it because that's the way I wanted it. I did not want the association to be able to interfere with folks and how they built their improvements.
Counsel, let me ask you about that language because you make the point in your brief that this declaration says what it says, even where it may be perplexing. And in this particular paragraph, the sentence with the reference to 75% reads, copies of such rules and regulations and amendments thereto shall be furnished by the association to all unit owners of the condominium with 75% approval. That 75, that with 75% approval seems to only be referring to the furnishing of copies. If I read that sentence, according to its language, to what extent are we permitted to go into the testimony of the drafter to find out what he meant? I mean, why aren't we confined to just what the language says here?
Well, if you see that as ambiguous, then that's the other principle I was going to talk about, which is that restrictive covenants have to be strictly construed against those who assert the power to limit an owner's free use of his or her land. And that's black letter law. And the association suggests that it's not. They cite Sweeney, but it says exactly that. It says exactly that any ambiguity has to be construed in our favor. And that it's always been, there's not been a dispute as to that language. There is no authorization for the association to give itself the authority to give use restrictions onto an individual unit owner's property.
So if I don't, let's suppose I don't read that second sentence, and we're limited to the language that says reasonable rules and regulations concerning the use of the condominium property may be made and amended from time to time by the association in the manner provided by its articles of incorporation and bylaws. If I stop right there, do the articles or bylaws provide a manner for adopting reasonable rules and regulations? And if so, what is that manner?
Yes, they do, but only for common areas. The association, the board is only authorized to adopt reasonable rules and regulations relating to use of the common areas. The negative implication canon would suggest that that means that they don't have authority to adopt rules for any other purpose. And again, it has to be expressly granted to them. It can't be ambiguous. It has to be expressly granted. That is the authority to adopt rules and regulations that would govern and restrict the free use of an individual condominium owner's property. The other side says that there's hardly a condominium in the state that doesn't allow restrictions like these guidelines. And I would say that that's patently untrue. I've owned 2 condominiums. Most condominiums are buildings, and I can gut the inside of mine, what I own, without any permission from anybody, because in neither of the condominiums that I've owned, there's been no use restriction allowed in the declaration in my unit. As long as I don't interfere with common elements or interfere with anybody else's property, I can do what I want to with my unit. And that's exactly the case here. The testimony was that there was never a 2/3 vote of the unit owners. That's clear in the record. That was the testimony of Mr. Thompson, the original developer, who testified, and then Matt Jordan, the association's general manager, testified that there was never a 2/3 vote of a unit owner, so that those restrictions were not adopted. And
your opponent makes the argument that any argument about the validity of the architectural guidelines or those rules that is a stale claim because that claim would have had to have been brought within, I think, 5 years of the promulgation of these things, and that we're beyond that. So we're not deciding that at this point, but just assume for the sake of argument that that's not available to you, and that the argument about unreasonable or arbitrary enforcement isn't available to you. And we look just at the fact that you didn't get the written approval. And I know you'll say, well, the exterior wall issue, but I just want to just focus on, assume that applies, that the fact that you didn't get the written approval of the association to build this second building or this addition. What limitations are there in these documents on the board's discretion to say no when you assuming you submitted everything to them and they reviewed it and they say no, we don't approve this? What limitations are there in the documents or in the law on the board's ability to say no when the declaration clearly says you have to have the written authorization?
If the declaration did say that you had to get their written authorization, it would be limited to the things that are in the declaration. They could look to see if you had an antenna, in other words, the use restrictions that are in the declaration. They could look to see if you were impeding on the common area. But they don't. I mean, if you look at the language in Article 5, Section 2C, that's where it says that the unit owners may construct improvements on their unit. An improvement is a new building, as he may be advised. And then there's one instance, it says if it would increase the cost of insurance on the association, the board has to approve the improvement. That's the only time that the board has to approve an improvement to a unit according to the express terms of the declaration.
What about
that distinction between improvement and a change or alteration, for example, to an exterior wall? But aren't there some structures that can be both? In other words, the use of those terms, are they mutually exclusive, or can there be such a thing as an improvement to lot 28 that is also an alteration to the existing building on lot 27?
The improvement to lot 27 was not an alteration of the wall on lot 28. They did not alter the wall in any way. They altered its character by the way they built the unit 27 unit. In other words, if they had put a millimeter between and put an exterior wall on unit 27, and then cut the same door that was in it so you could still walk through the door that was in unit 28, then unit 28 would still have that exterior wall. But it doesn't have an exterior wall because they didn't put an exterior wall on 27. Now it's an interior wall. But they didn't alter 28 at all. They altered its nature.
They did have to stick something to it, right? I mean, when I look at the pictures, even the framing of the second building, it's touching. I mean, it looks like it's stuck into it. And then when I look at the completed building, it looks like one building. So they did, whether they used glue or mortar, or I don't know how they did it, but they stuck that second building onto the other building. Isn't that a change to the exterior wall of the other building?
It's adjacent, but the only evidence is that there was no alteration of the exterior wall. That was the testimony, and that's what's in the record.
When you say, I'm sorry, go ahead.
That's okay, Judge.
No, go ahead.
But do you agree that it's now an interior wall?
It is, yes.
Okay. Go ahead.
It wasn't clear to me in the record, but following up on Judge Gannon's question, it looks to me like there is only, would you agree there are, how many structures are on your client's lots? Is it one larger structure than before, or is it two separate structures?
You could call it either. I mean, there's
What does the city call it?
The city permitted it as a separate structure.
They permitted it as a separate structure.
Yes.
Isn't that in the record, the permit?
I mean, I don't know if the drawings are in the record or not, but they submitted the drawings for that structure, and it called for no alteration to the other structure that was adjacent to it.
It wasn't considered an addition to the existing structure?
I don't believe the record reflects that, no. And there is no use restriction that prohibits owners of adjacent units to complete, if that was a single structure over both units. In fact, there are others out there that are over 2, and there's one that's over 3, and that's in the record. Over 3 different lots, the same structure, but.
Well, I guess my question is though, if you have an existing structure and then if the record reflects that what this was an addition. And so would you agree that if you have an addition that expands the footprint of the structure and you essentially take a wall that was 100 feet long and you now in your addition extend that wall another 100 feet, would that be a change or alteration to the wall
I
of the
would,
structure that was there by you're increasing the linear square feet of the footprint of your building around the circumference, I'll say?
it would be a change in the appearance, but
Right.
if you're taking one and putting it right up against the other, you're not changing the original unit 28. You're not altering it. And I would say, it would be just strange and odd if the law, which it does, requires a clear grant of authority, unambiguous, and the declaration says that a unit owner can improve their unit as they deem fit. There are no use restrictions in the declaration. The declaration and bylaws do not give the board the authority to adopt use restrictions. They don't have that general power. That somehow, because of this line about altering an exterior wall, that they now get to adopt guidelines that are designed for a freestanding structure. I mean, they didn't impose these as the guidelines we have for when you have an addition. These are the guidelines that they say that they have adopted and have the power to adopt to control the owner's use of their lot, even if they're building a freestanding structure. As a matter of fact, that's what they're intended for. So, I mean, it would be completely ambiguous to look at this document, look the declaration that's recorded and say, oh, okay, now if you build a structure, if you have adjacent lots and build the structure right next to it, then the board has the authority to adopt architectural rules to govern that, but doesn't have the authority to adopt architectural rules or other use restrictions to make an improvement on your lot in general. So, I mean, because that's the way they've applied.
I'm sorry, you're in the
I'm
bubble.
over.
Do you have any more questions? All right, thank you. All right, counsel, I'm going to give you some additional time. Again, you don't have to use it if you don't need it.
Okay.
All right, go ahead.
Thank you, Your Honor. May it please the court. I'm Christian Waugh on behalf of Appellate, Orlando, Apopka Airport. I'm joined by co-counsel Avery Dyan. Appellant built a condo without the association's permission. It didn't ask for permission, didn't get permission, didn't get forgiveness. And Your Honor, sometimes people believe it's okay to ask for forgiveness later. In this case, they just haven't gotten either. Now, appellant's position is that despite all the length of the declaration, the length of the association, I could do the weight test in front of Your Honors, that there's no authority in there for the approval of the construction of a new hangar. I want to address some of the court's questions from the get-go.
Can you address the authority issue?
Yeah. Well, in the first matter, Your Honor, I think frankly, the strongest point for my client is the language in Article 5, Section 2C, talking about requiring association approval when there are changes or alterations to exterior walls. And what I just heard in the oral argument, I thought was really interesting, because in response to the court's questioning, I think it was posited to the court that no matter what was appended to Hangar 28, the pre-existing hangar, no matter what was appended to it, and it's unarguable that something was appended to it, that there was no change to that exterior wall. And yet, the declaration is very clear, if you attach an awning to something, a shutter even, that is a change subject to approval under the declaration. And if a shutter and an awning would be subject to approval, changed to an exterior wall, why wouldn't an entirely new hanger that's appended? And there was a great point, Your Honor, about whether or not there has been an exterior change. You don't have to take my word for it. They say that pictures are worth 1,000 words. In the record at page 2454, there's a picture of the hanger, the new hanger, hanger 27, being bolted and jacked into the wall on hanger 28. So I don't think at all that it's the fact that there's no change to an exterior wall. Again, authority, Your Honor. First, start at the beginning, a very good place to start, as they say in The Sound of Music. Article 5, Section 2C. And then
Is that authority to adopt those restrictions? Because that's my understanding of it. So I have 2C here in front of me. But it's my understanding. So is in your mind, is there any dispute that the board would have had authority to adopt such restrictions?
No doubt, Your Honor. And there are several reasons as to why. So I think that the board had authority. First of all, there's a couple different issues with Your Honor's question. I want to maybe delayer it a little bit. In the first instance, if we assumed arguendo that the ARB was valid, and if we assumed arguendo that its rules were valid, the guidelines, so to speak, even those provide for board approval in the end. So there's no getting around, no matter which way we go, board approval. Now, in terms of the authority for creating the rules and the ARB itself, the bylaws, Article 10, which were recorded with the declaration, state that an architectural control committee shall be created. Now, attendant to any architectural control committee, if the association is to apply fair, reasonable, uniform decisions, they need some kind of guidelines. These guidelines are to protect appellant. And so that's why they are promulgated. There's authority for that too. I would refer the court to not just Article 10 of the bylaws. Article 7 of that declaration states that the association has the power to operate the condominium. Florida statute section 718.111 subsection 2 augments these authorizations by saying that the powers and duties of the association are set forth in the declaration, bylaws, and chapter 617. And chapter 617, which as we know governs the not-for-profits, indicates that bylaws may contain any provision for the regulation and management of the affairs of the incorporation not inconsistent with the law. These rules are not inconsistent with the law. What they do is they establish reasonable regulations on how hangars are built. And by the way, a pretty special community. This isn't just like any regular condo. This is an airport community. And it's a beautiful one as you drive south on 441.
Mr. Wall, let me ask you, getting back to this authority issue, and I'll ask you the same question I asked the appellant. Assuming there are no ARB guidelines, there's no written rules anywhere, and all we have to go on is the language in the declaration that says you must get the written authorization of the board in order to do this, to build this thing you want to build. Is there outside of the declaration in the law, or is there something in this declaration that puts any limitations on that? Or is it absolute?
I think that's a fair question as someone who has considered buying into associations before, Your Honor. And the answer is yes, there are standards. It's not unfettered discretion, and there's case law on this. I mean, as a general matter, an association can't arbitrarily and unreasonably look at something. In other words, it can't go out there and allow something to willfully and intentionally allow something on one hanger and then not allow it on another if it's all fair game, unless there's some particularized concern over health safety. So, if one hanger was able to have an electrical panel on one side of the building, it may not be appropriate in another hanger if it's next to the runway, that kind of thing.
And I take it your argument would be that anything having to do with sort of the reasonableness or the consistency and enforcement is not available to the appellant here because of the affirmative defense issue, the one that was dropped and that they tried to add back in later. I take it would be your argument that that's just not on the table, that it's simply the fact that no written authorization was obtained is dispositive here.
That is my client's primary contention on the matter. We do talk about that in the answer brief. But in addition, I do point out also to the court that I don't think there's even evidence in there that the ARB did apply these rules in different ways anywhere. The evidence in the lower court shows that My client never even got a completed application. In other words, they were waiting. There's boxes that you have to tick for management plans, drainage plans, other things, complete plans. And incidentally, we know this because in the discovery, when my client instigated the lawsuit, it didn't actually know at the time that there were going to be inside, that the wall wasn't going to be blown out between the hangars. In other words, they had kind of assumed with this new hangar being built, you see this in the depositions, they thought that maybe what Appellants was going to do is just blow out the wall and have a mega hangar. That's actually not the case, you know, and so they found that out later. But that was something they thought was going to happen. And I want to also answer a question from Your Honor, Judge White. Your Honor had asked learned opposing counsel about how this hangar was permitted, and that is available in the record. The Bates stamp is ASM 000217. I'm not exactly sure where it is in the record. I have a copy of it. When it was permitted with the city of Apopka, it was permitted as a quote addition to hangar 28, and that is very clear on the document. So. In addition, I mean, I think
in terms of, in response to Judge Gann's question, you said your client's position was the appellant did not submit the application. And so I understand your other arguments, but if we were to conclude that the only basis for your client's authority is in the declaration itself, and so there's this language says first obtaining approval in writing of the association board of directors. So I understand your argument there. But then the judge's ruling though went beyond that, didn't it? I mean, it talks about, says in furtherance of the above, defendant must submit a new written application. That makes sense with what you're saying. That comply with the guidelines. Okay. Let's set that aside for a moment. By including drawings and plans, including a new roof. I guess my question is did your client request more relief than just order the appellant to comply with the application process? Or did you also request, because I gathered from this order and some of your arguments that you also said, and here's what the application needs to do.
I think it's very difficult. And Your Honor, the answer to your direct question is no, I don't think that the association requested necessarily every detail of what the trial court would have said, as the court just quoted it. However, I do think it's consistent with what we did request, which was that the association can't judge anything without a completed application, essentially, Your Honor. So it's very difficult for them to make heads or tails without all those plans, because on this kind of a condo, again, not just a regular condo, one that has FAA issues, those have to be meticulously looked at.
Well, let me ask you this. If we're limited to the declaration, what would you point me to that would be your client's authority under the declaration if a unit owner says, we're replacing our roof? Do you believe that would have to be submitted to your client for approval?
Yes, Your Honor.
Okay. And based on what? What language of the declaration?
Yes, Your Honor. Article 5, Section 2C is the primary one. However,
This is the alteration improvement.
Yes, Your Honor.
Section. Okay.
Yeah, and I think it's, frankly, I argue to the court that this is fairly broad. And when read with the rest of the provisions of the declaration, and I think that's what Florida case law stands for, that it needs to be read together to be consistent. What we're looking at is a comprehensive scheme for regulation of these improvements. Now, I think the assumption with Your Honor's question is that in that scenario, we're assuming the ARB rules are not at issue. We're just looking at the declaration itself. Yeah, I think that's what would be the case, Your Honor.
And so is it your argument that let's assume, if we find that there was basis to conclude, to grant summary judgment to find there was a change or alteration to an exterior wall, window, structural, load-bearing wall, or color, that if that predicate fact is established, the approval can be contingent on other requirements that have nothing to do with those specific named elements of a building. For example, what kind of toilets you have, what kind of counters you have in the bathroom.
If I understand the court's question correctly, I don't think that the association reaches that level of control.
But they could. Is that your argument?
Yes, with the governing documents. And I think that actually this declaration is very much on point with what our position was in the answer brief, and frankly, learned opposing counsel's characterization of associations. This document doesn't yet say exactly what picture frame one can put on a wall, but it does regulate the things that are visible through the windows. And I think that's another point, that when we read it all together, this is not a document that is a laissez-faire document. This is one that is pretty strict. And that's why the bylaws come in and say, hey, this is why we need an architectural control committee. So I think that's really the basis for the authority. I wanted to also address the statute of limitations issue if I could. I actually think this is a very compelling issue. The court may notice that in the record, at one point, appellant sought leave to amend its affirmative defenses prior to summary judgment, and in addition to assert a counterclaim and third-party claim. My client opposed that. The court granted it in part and denied it in part. The court granted the motion to allow them leave to amend affirmative defenses. They shed some affirmative defenses, including the arbitrary enforcement one, but they were denied as to the ability to assert a counterclaim or a cross-claim. And the counterclaim is very interesting because the counterclaim alleged that the ARB authorizations were ultra-virus. So if they had proceeded or been able to proceed with that claim, maybe they would have gotten it in time in the 5-year statute of limitations to challenge the 2016 rules. But as we sit here today in 2025, it's just not at issue. And the cases that I provided, frankly, they were surprising to me. I was surprised by the fact that you could have a 5-year statute of limitations for even a special resolution from a city for special assessments. If illegally enacted, if you don't challenge it within 5 years, it's tough. And I mean, it's prohibited. And here we have rules, multiple cases cited in the brief.
Do those cases involve a defendant or an affirmative defense? Or is that?
No, Your Honor, they don't. But I actually think that supports my client's claim. An affirmative defense isn't enough to strike down something. I mean,
isn't there case law that says that you can assert a defense regardless of the statute of limitations? It only applies to an affirmative action. That is, if appellant instituted an action against your client, statute of limitation may apply.
Right.
But if your client sues the appellant, you're saying the statute of limitation applies to what defenses or arguments they can make against your enforcement.
If it precludes as a matter of law the basis for the defense. In other words, if their defense is something that's precluded by an application of this case, then yes, I think it goes away as summary judgment.
Which case would you cite me to where the person challenging the association's action was the defendant?
Person challenging the association's action.
That they raise it.
I cannot do that. I cannot do that, Your Honor. The cases that I cite are from plaintiffs challenging the validity of the documents. And in Hilton v. Pearson, 208 Southern 3rd 108, this is actually a case where they were challenging, the plaintiff was challenging the validity of an amendment to a condominium governing document. So there are actually 3 orders under challenge here. We've only talked about the motion for summary judgment order. And I think that is the crux of the case, frankly. We do ask this court to affirm all the orders. There are motions for reconsideration that have been appealed, orders on those. An order for motion for leave to amend affirmative defenses 18 months after summary judgment. That is here under appeal. And we ask the court to affirm as well. Otherwise, we stand by the terms of our brief, and I welcome any other questions. Thank you. That concludes my argument.
Your Honors, it is
Oh, hold on.
Okay. Clearly, it is clearly the law of Florida that for an association's board to be able to adopt use restrictions, reasonable regulations or restrictions on the use of individual condominium owners' property, that grant of authority has to exist in the recorded declaration or other recorded restriction that runs with the land.
Counsel, on that.
Yes.
I believe Appellee's counsel argued that in the bylaws, which were recorded, there was this reference to an architectural review committee shall be created. I may be paraphrasing,
Yes.
but you understand.
It says
Okay.
it shall be created as established in the declaration, and there's nothing in the declaration about that. And that alone would not be enough. The minimum language that you need is that the board of directors may adopt reasonable rules and regulations to concerning the use of individual condominium property. That is the least, the most general language I've found in any case. All the other cases, including the cases that are cited in the declaration itself, it establishes an architectural review committee and gives express power to control the aesthetics and architecture of the units. Every single case, the very minimum is a grant of power to adopt rules and regulations to control the use of an individual unit. And there is that language in here, but it applies only to common elements. The negative implication doctrine means that why would you have that in there and say only to common elements if you intended it to apply also to individual unit owner property? And then in addition, when you ask where is your authority, the only place they could point to was Article 5, Section 2C, which is a section that says with respect to improvements, a unit owner may make such improvements to his unit at his sole cost as he may be advised. And then goes on to say that a vote of the board is required before an improvement is made that increases the cost of insurance.
But what about language earlier than that, counsel? So further, a unit owner shall make no change exterior wall, window structure or load bearing wall or color of any exterior wall or awning without first obtaining approval in writing of the association board of directors.
So my not a question to you, but rhetorical question in response is, would anybody reasonably suggest that that authorizes the adoption of architectural guidelines for new construction? Alter an existing exterior wall.
But that is what they did, right? If an exterior wall becomes an interior wall, aren't they altering that wall?
I mean, if that were, I don't think so. I think it's a change to the character of the wall. But even if you say that it is,
Well, counsel, if it's a change, the language says no changes or alteration.
to the character of the wall, I said, not to the actual.
So
wall.
it's
But
a
assuming that
change
this was
to
a
the
change
character of the
unit 28,
exterior wall, but not a change to the exterior wall itself.
that would be my argument with respect to that. But this would be a ruling that the architectural guidelines do not apply to a new unit construction because there's no authorization in here for that. An improvement is a new building, and with respect to improvements, the only time that board approval is required is if it would increase the cost of insurance to the association. Okay. So their architectural guidelines, which are intended to apply to all improvements, don't. They only apply if you buy a unit that's adjacent to yours and then put a new unit. But if you do that, then they get to control everything, including things that aren't in their guidelines, but they get to control everything. That just doesn't make any sense. That at most is an ambiguity. It certainly doesn't give them the authority to adopt rules and regulations that for improvements on freestanding single lots couldn't.
But this one, we don't have just an improvement or a change or however we want to call it to the lot, to the vacant lot, so to speak, right? that change also bears on the other lot that already does have the structure on it, right? So
Okay.
we're not in this sort of like clean world where there would just be nothing and then something. Instead, we're combining them, thereby making changes to
Okay.
the other one.
So if they had the authority to approve prior to only those new unit constructions that were adjacent to an old unit, because the owner owned both units, if they had that authority, then the regulation of that would have to be solely attendant to what happens to that wall. In other words, you couldn't then say, okay, well, we want to control whether the new structure is ADA compliant. We want to look at your plumbing. We want to look at the color of it. We want to look at everything else about the new. We can't do that if you had moved it over and built it as a separate, but we now can do that. This just doesn't even make sense. And certainly this document does not put a unit owner on notice that that's what's required. I know that I'm over, but I have to say that the narrative that he just didn't ask permission is so contrary to the evidence. He asked 6 months in a row. And then when he got no response, he went ahead and pulled the permit and posted it across from the manager's unit with all the plans for a month before he started. He then finally started, and when they asked him to stop, he stopped. They call him into a meeting. He goes to the meeting and they say, "You never applied. We have no idea what you're doing." His representative, who he had hired to shepherd this process, said, "I have the email receipts. I followed your 6 months worth." And then they said, "Oh yeah, we do have them, but we have questions about them. Bring him tomorrow." He brought him the next day to the manager's office, who looked through everything and said, "Yeah, this is good. You should-" Okay.
May I ask, counsel, one more question?
Yes.
Would you agree? I can't remember which, if it's 27 or 28 that has I feel like is it 28 that had the existing structure on it?
28.
Okay, so if your client wanted to, is it beige? I feel like it's beige right now. Hypothetically, it's beige right now, okay?
Yeah.
If he wanted to paint it green, does he have to, would you agree that he has to ask the association's permission to paint the entire exterior of 28 green?
Yes.
But not if he's going to change. So then it must be your position, counsel, that that the exterior wall becoming the interior wall is not a change or improvement, right? Because it's the same sentence that I'm looking at. I know I'm in my own world here, but I'm looking at Article 5, 2C, right? So further, a unit owner shall make no changes, to the color of any exterior wall without first obtaining the approval. That change or alteration to any exterior wall is in the same sentence. So if he would have to ask permission to paint it green, then I would think by virtue of the same sentence, he would have to ask permission to change the nature, character, whatever you want to say, of that exterior wall. So is it then just it's not just your position though, that the wall just didn't change. It's further than that.
What I would say is that that sentence does not give the board the authority to adopt architectural guidelines for new structures. And that's what they attempted to apply to him. In other words, they never said once that we have a problem with the wall. What they said is the roof pitch isn't right, the plumbing isn't right, the electricals, we have a problem with that, we have a problem with this and that. And those are all things that had to do with the new unit improvement. And with respect to improvements, what the declaration says is that the board vote is not needed to an improvement unless the cost of insurance increases, and it did not.
That answers.
Thank you. Yes.
All right. Counsel, very well argued. Thank you for your preparation and oral argument here today. We'll be in recess.